Welcome to your favorite show, Law and Order. Wishing you a pleasant day. Today also we are going to discuss one of the most important areas. So ladies and gentlemen, we might be working for someone or a company, or sometimes we might ask someone to work for us or a group of people to work for us. In that particular context, we need to know the law behind those things. So it's none other than the labor law. Not knowing the law is not an excuse. So to discuss about the labor law, we invited the senior counsel, Mr. Ian Fernando, attorney at law. So thank you very much once again for joining with us with today's program.
Welcome, Charit.
Right. So in order to give a quick start up to our discussion, labor law, when we discuss this labor law, always there's a person who is offering a job opportunity for some person and some person who is working for someone. So who the employer is?
That is called the employer-employee relationship. And there's a difference between employer-employee relationship and an employer who employs an independent contractor. When you have an employer-employee relationship, it's a contract of service. You are having a contract regarding his service by the appointment letter. Wherein you have a contract for services is like you have an independent contractor who comes and paints your house or builds a house for you. For examples, the employer-employee relationship, though a doctor or a surgeon is doing a surgical operation, he is not an independent contractor. He comes within the purview of the hospital unless you have hired him from out. If he is a hired doctor from out to do the operation, then he is an independent contractor.
Right. So we termed who is an employee, who is an independent contractor in a certain scale, sir. Like if I am working for a certain company, there are certain consequences and differences whether the job that I perform in a certain sense is permanently fixed or something like I'm doing a part-time job or something like that. There are different scenarios dealing legally. So how can we clearly distinguish what type of work that we perform? So as ordinary individuals, people might not know what they are performing. They might know that only for the work done they will be paid, even a monthly salary, daily salary, or any wages that day. What is the real scenario?
There are different types of employment. There is permanent employment, employer-employee relationship. There's contractual relationship where you have an independent contractor who is coming to work for you. You can have casual workers. Casual workers can't work more than 6 months continuously.
Right.
And then you can have probationary workers who only work during the probation time. That is normally 3 months or 6 months. And it can be extended maximum up to 3 years if you are not satisfied with the probation period of the worker. For example, after the 6 months, if you think that he should be extended, you should give him a letter stating the misconduct or the less work efficiency that he has got. Stating that, you can increase the probationary period.
Right.
However, if you don't give a letter after the probationary period, you are automatically termed to be that you have got into the permanent employment. So you get piece rate system and casual work, as I mentioned earlier. Those are the different varying types of employment.
When considering the time of employment or whether the work hours that we perform or the specific time duration, is there any particular difference, sir?
There is a particular difference between the factories ordinance and the Shop and Office Act, which normally deploys the workman onto how many hours of work, and there are limitations on the years of work or the particular time period. Basically, the hours of work is really defined in the Shop and Office Act and the Factories Ordinance. So, if you are wanting them to work for a continuously long time, you can have a contract signed between both parties, setting out all the different duties that they have got to do and what their termination clause or termination period is. You can set out all that in the contract.
Right. Okay, sir. Then when it comes to the independence of the decision making or the work that they perform, what is the difference?
The independence, those are regulated by what is called the control test and economic test where if you are an independent contractor, you cannot be hired and fired. You work on a specific purpose. You don't have to give EPF and ETF to an independent contractor.
Right.
But to all other employees, you have to pay EPF and ETF, including casual employees and the probationary period. All employees are entitled to those benefits.
Right.
So you can distinguish their employment on the job that they are doing and their performance. You can give them the performance indicator where you give them a performance allowance
Right.
and various other allowances to bring them up to the standard, a par with the other companies that you are progressing with.
Right. In certain contexts, before certain employment opportunities, they need to offer a certain training period. So what is the real legal scenario? Do we need to get paid, or can we work for free?
Yeah, the training period, as I mentioned, is the probationary period. How a normal employer will look for employment of employees is he'll put an advertisement in the newspapers or in any public site for you to apply.
Right.
And if you are shrewd enough to apply with the same wordings that he has given, where he's expecting you to have the expertise on that particular area with a similar connotation or similar meaning, you will get pulled up for the first interview one go, because the requirement that he needs you for, you are applied. So that is one of the hints I can give for any purpose of any person who wants to apply.
Right.
Your curriculum CV and your CV has to be spot on. It has to adhere to the requirement needed by the employer. So thereafter he will take you on the probation period and work you out, and once the probation period is satisfied, he will give you the permanent employment where you will be entitled to so many benefits.
Right. Okay, so in that scenario, sir, you explained us about the contract of service and contract for service. So what is the real importance of distinguishing those two contexts separately?
When you are an independent contractor, you don't come within the permit of the Industrial Disputes Act, Act number 43, in which you will be called upon if there is any dispute regarding your labor matter. The Industrial Disputes Act and the Labor Tribunal goes into employer-employee relationship. Basically, if you are terminated, you have to come within at least 3 months to 6 months, basically, to file your claim to get in your compensation and back wages and for reinstatement.
Right.
If you come later than 6 months, your application will be time barred. So that is one form of redress that you can get under the Industrial Disputes Act in the Labor Tribunal. You are only entitled to your back wages and reinstatement. All other matters relating to employer-employee relationships otherwise comes before the Commission of Labour, which in different cities you have the Assistant Commissioner of Labour. So your non-payment of your salary being withheld, your EPF and ETF not being paid, your gratuity not being paid, you can go before that particular Assistant Commissioner of Labour and make a complaint that your EPF and ETF is not paid.
Right.
Those are statutory dues, and those, if you flout those decisions of paying your EPF and ETF, if it's a limited liability company, incorporated company, the director's assets are personally liable.
Right.
That is set out in our Companies Act in Sri Lanka, very specifically, that if the directors fail to pay the EPF and ETF, they can be brought into custody and they could be remanded until those monies are paid. And there was a criminal court case where you cannot challenge the certificate given at the Commission of Labour on EPF and ETF you have got to pay. You can only challenge it by way of a writ in the appeal court or the high court about the non-payment of EPF and ETF.
ETF, right. An important area, an important discipline in that particular context. So moving a little bit forward, if we are diagnosed with a certain disease, by performing a blood test or urine test or whatever it is, we can identify. In this employment scope, what are the tests, or are there any methodologies to check what scope of employment we are
Yes, I mentioned the economic test, that is whether your salary is paid by the particular employer to employee. That's called the economic test.
Right.
Then the other one is a control test, who has right of control over you, whether you can be hired and fired by that employee. and there are other tests as well, whether you take the commands of the particular employer and employee, then it comes the employee-employee relationship. Also, if the EPF and ETF are paid by the employer and employee, then the employer-to-employee relationship is substantiated. But in an independent contractor, that EPF and ETF is not paid. So that's an economic test about how you can distinguish the two people of a servant and an independent contractor. There is a recent situation that arose that company A, a particular employee A, is suing company B for his workman's compensation, and company C is the one who is paying the EPF and ETF and holding the investigation or the interviews to employ people. Company B only collects the computation and passes it on to C to make payment. But company B's name is there on the EPF card, and on the ETF is the person who is depositing the money. Now the question is whether who is the employer. So the position taken up was that by the counsel in that case, that the company C is the person who interviews and fires the person. Therefore, necessarily he must be made to be the employer, was argued in court, whilst company B was only just a post box in transferring the accounts and the work done to company C for payment.
Right. A wonderful decided case and a good advice for you all with regard to that particular court experience. And so, like, moving a little bit forward, if I am hiring a person to work under me, if he does a certain mistake or commit a crime, will myself be liable for that?
You will be liable to the extent vicariously up to what extent he has done the particular crime. For example, you have a storage where you have your sugar and flour and things like that, and the storage partitioning falls onto another company which has maybe mobile cars for sale, and that fell due to the fact that your driver has unloaded the stuff in a wrongful manner. So there the owner is vicariously liable if he has unloaded the stuff in an unlawful manner and caused hurt to a third party. So in an accident relationship also, if your driver is driving with your consent and he meets with the accident, you are also vicariously liable for the accident. But you can't take up the position that he was not within the scope of your employment, that you asked him to drive the car and come back home till 5 o'clock, you were waiting for him. But he has gone on a jaunt and he has arrived at 6 o'clock after doing some marketing of his own, and then he met with the accident. Then you are not liable to pay because he doesn't come within the official measure of the scope of employment.
And in that context, if a parent company employs a certain subsidiary or something related to, if that particular mother company employs that small his subsidiary company in a certain particular endeavor, if they commit a crime, will the mother company be affected?
If it's the agency principal relationship, the mother company is liable to pay. But there will necessarily be a contract between the parent company and the small company, the mother company. So that will have to be looked into first as to see whether they are taking upon themselves the vicarious liability or not. Charita, there is a very important area that I must tell you about gratuity. People are entitled for a company which has about 15 employees or more. If you are work for over 5 years, you are entitled to half month's service for every year of service that you have done as gratuity. So if you are getting 100,000, you are entitled to 50,000 into the 5 years, 250,000 at the point of leaving the gratuity. What most employers do is find some mistake or some robbery caused by you and enunciate a case in the magistrate's court that you are not a gratuitous person to the money to be paid because you are a thief. So once that case is pending, until the final determination of that case, your gratuity is withheld. Gratuity will not be paid. So that's a very important area. People who are looking at big sums of gratuity, that you might not get your gratuity if you fall out with the employer. he might formulate a magistrate's court case against you with the auditor, saying that you have committed some fraud and you will not be entitled to get your gratuity.
So in that case, when moving a court case like that, is it harming the rights of the particular employee?
That will be seen at the end of the case. If it's termed that there was no criminal act that he has done, he will have to pay the gratuity with the required payment for interest. Even the EPF and ETF, if you do not pay on time, for the first to 10 months, there is a particular percentage.
Right.
For the first month, there is a particular percentage. Thereafter, that percentage starts increasing
Up to
and
somewhere around
finally
50 or
ends up at
something
50%.
Yes.
So if you do not put the EPF money into the account with the B card to the central bank, you will be found liable.
பண்டாரவளை ஸ்ரீ சிவபத்ரகாளியம்மன் ஆலய பிரதம குரு சிவஸ்ரீ சர்மா சுவாமிகள் கலந்து சிறப்பிக்கும் பாண்டவ ஜோதிட ஆன்மீக விளக்கம் சம்பந்தமான நிகழ்ச்சி ஞாயிறு தோறும் காலை 9 மணிக்கு உங்கள் நேத்ரா அலைவரிசையில்.
If a certain worker, he needs to be paid by the company or the employer who is being employed under, in that particular state, if he is not being paid, is there any particular state institution or any governing body to intervene?
As I mentioned, only the Industrial Disputes Act will empower the Labour Tribunal to reinstate you and to give you back wages.
Right.
But however, all other matters come before the Assistant Commissioner of Labour, Commissioner of Labour. So if your salary is not paid, you can go and demand for your salary by a complaint. But Charita, the normal concept that people think that if you do not take leave, that for that leave you will be paid. Some companies do pay, but there is no legal requirement to pay.
Right.
So if you are on the view that just because I didn't take leave, I am entitled to the pay for that particular day, that is not the scenario, because the company must have a policy that they pay for leave if not taken as a salaried worker on that day.
Right, that means there is no any legal requirement to pay in such context. And so you explained about the Labour Tribunal. What is the real legal background of the Labour Tribunal?
Labour Tribunal gives an award, and if you are awarded and you do not pay, then they can enforce that particular award against you in the magistrate's court. Also, if you fail to the case and you want to appeal, you have to come within 1 month from the date of the order to the High Court, and you have to deposit the entire sum that the particular applicant or the plaintiff who put that Labour Tribunal case is awarded with. That entire sum has got to be formulated into the High Court in cash as a security, and then only you can start the particular case, the High Court appeal.
Okay, so moving into a different discipline, if I am an employer, I am going to work with a minor, but with his consent.
You are not entitled to work with the minor with his consent until he passes, basically the age of majority under that act is 18. You are not entitled to make him work as an employee, but you can before 18 have a person for training. He can start working. Right. For example, if you take the chefs, there are students who are 15, 16, 17
from hotel schools
who are learning and who are paid allowance, but there is no proper legal contract there. The fact that they are under training, they are being paid.
Right.
And they are employed after the age of 16, but they cannot get a letter of appointment until they are 18.
So I'm bringing down a foreign individual, a foreign citizen here in Sri Lanka to work under me. How the law applies?
If you are under the BOI Act, BOI provisions apply, and you will get certain concessions on those, but he will be taxed on his salary, and minimum for the first slab on the tax department, if you are getting 3 million for the year, you are taxed at 6%.
Right.
And thereafter, if you are getting another 3 million, that is 6 million for the year, you are taxed at 12%.
Right.
So according to whether you have provisions under the BOI Act, under which form or which section under the BOI Act that you have been registered, you are entitled to work a foreigner with the consent, and then his allowances also have got to be paid by you. is housing allowance, medical allowance, all those matters will have to be attended by you.
Right. So that was the final point that I wanted to reach. With the health and safety measures, what are the duties, the duty-bound concepts of the employer with regard to employees?
The medical allowance scheme that they have is not a must, but certain employees have, where you are reimbursed for your medical expenses. There are certain medical aspects that the employer has to look into. If you are a mother who is to deliver a child, a pregnant lady, you are entitled to 84 days leave according to our Sri Lankan law. According to the law of Australia, not only the maternity leave, there is paternity leave, where the father can take time off once the child is born to look after the child for his first few months. That provision of the law has not still come into Sri Lanka, where the father is entitled to stay at home to look after the child if the mother is working.
Right. So one more different discipline, sir, if a company is existing and there are certain insolvencies and they are going to wind off and winding up of the company, there are certain scenarios that the employee might lose their job opportunity.
Yes.
In that scenario, can't we claim demands as the employee?
You can claim the demands as the employee. Then there is what you call industrial arbitration. The whole trade union will go into the particular company, to the labor office, and file a case for industrial arbitration and mention that they have worked for so long, and accordingly that some redundancy payment should be made for them to terminate their services. At that point, there are certain rules and regulations that the assistant commissioner has got to go through, but it is a consensus that is reached between the employer and the broken down company to pay the employees' dues that are statutorily due, have got to be paid, but the salary and other things can be negotiated. Now we see during the COVID time that certain companies have come down in their business and are unable to pay their salaries. The question is whether you are entitled to pay the full salary or not. Certain companies paid 75%, certain companies even paid less. The scenario there is that you are brought before the Assistant Commissioner of Labour, and if you can show your accounts and details that you have really gone down in your business, you might be able to get some relief from the employer-employee relationship by coming to an agreement between the parties. But the inquiring officer has no right to tell you that you have got to pay so much or you have got to pay this much. If the statutory due is there on your salary, you have to pay the full salary. So the negotiation of you between the employer and employee, where the labor officer will help you, and how best you put forward your cards on the table, you can, on a COVID situation, get a reduction of your salary.
Right. Okay. So that was a very interesting area that we were discussing, and finally I want to concentrate on a specific discipline, sir. If we are working, we are getting a certain sort of a document as the appointment letter. So what is the real legal validity? Because some people are not keen on collecting those documents and maintaining a proper file.
The employer is not very keen on giving you an employment letter, because that straight away shows that you are employed, but you have a legal right to get that, and that employer must state out your job functions, what are your attributes of the job, and what's the salary you are getting for a month. And even some letters go to show that on what grounds you can be terminated. So in that context, that employment letter is a must. Some employees don't give that employment letter, and at the end of time when you ask them for a leave-in certificate, as per the law, they just say that you have worked from this date to this other date and don't state anything about your employment, which they are entitled to do if they don't like your face. So they can just say you were employed from 1st January 2001 to 22nd of April 2022.
Right.
But certain employees go more than that to give you a work certificate, which you are not legally entitled to, but you can request for same and give you a glowing certificate which will enhance your employment in the next business or employment that you are going to take place.
Right. Okay. So that was a great explanation, and the particular flow that we ran through here with this discussion of labor law is that the scope of employment, how they should perform, and certain liabilities, consequences, and finally we came to a certain standpoint where some people deal with collecting of the appointment letter and some certain situations where the companies are being winded off, risk of being losing their employment, so on and so forth. So ladies and gentlemen, with this program Law and Order, we are concentrating certain disciplines that will give you a certain knowledge to understand the real legal scenario, as not knowing the law is not an excuse. If you're fallen in trouble, you can't say that you doesn't know the law. You must, and as the program Law and Order runs, so you can regular with the program and gain the knowledge that we share with. So today's discipline was labor law, and thank you very much, sir, Mr. Ian Fernando, Senior Counsel, for joining with us with today's program. So stay tuned with Law and Order program. So we'll be discussing more interesting topics in the future as well. So thank you very much for watching. Have a pleasant day.
That at 18